I told you you can't have contact.
Yes, ma'am.
And you're the one that can go to jail. Mr. Kimler, you've got Brandon Bell.
Bill?
There's not an agreement on this one.
I'll defer to the state.
There's not an agreement, Judge, and I do have the complainant for the underlying offense as well as Ms. Lopez here. She may come up, I think the court might need to admonish both of these individuals per my conversation with Ms. Lopez.
Okay.
If you've gotten to the point where you're frustrated, Ms. Lopez, you know there's an issue.
So are we going to go through the motion? Or what's,
Yes, please, Your Honor.
so let's do that first. Good morning, Ms. Lopez.
Morning.
And sir, you're Brandon Bell?
Yes, ma'am.
The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So I.
Give me just a second to get that pulled up. Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to. True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
Okay. So that would be true that you haven't successfully completed it, right?
Yes, ma'am.
Okay. Count 7 alleges that you failed to,
I think you should say not in there, Judge, I'm sorry. You failed to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection?
Objection.
So 7. Hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025. And is that true or not true?
True.
You understand adulteration? And the court could explain it. I don't think he-
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No,
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that or not? That you admitted to drinking something?
So it says you admitted to the adulteration of your urine analysis, which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
Well, any piss test, I
Urine
had.
test.
Urine, listen.
Any urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true.
Count 10. Let's see. Actually, count 9. Hold on. I'm out of 6, 7, 8. What I missed here. Count 9. So this goes over here. Alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You said it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. Let me look back at something real quick.
David?
When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with Spinaltop?
You mean mental health or
Mhm.
drug treatment? Mental health, yes,
Okay.
yes.
Weaver? Oh wait, Your Honor, I apologize. August 18th was his last drug test and he tested positive for THC. He has since been drug tested again in September and it was negative. I gave you the wrong date there.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to this.
So last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week and she admitted that they had been seeing each other that day. And she was angry but it's very inconsistent whether she wants to be around him or not. Some days I get calls.
Well, but I told you
To come back in front of you.
Just be quiet.
you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some Spinaltop, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for an updated pre-sentence report. We can have any other testimony at that time with regard to the other allegations that are still pending. If you have any witnesses, then
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
what my preference would be, may she come up to be addressed by the court?
Yeah.
Ms. Bell? The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what,
Look this way.
what is, I don't
You
know the
look this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together, and that in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well, is that right?
Well, that's why,
They're pregnant now, is that right?
but that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our managers are in the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go, and obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay,
But
then
he's
it's,
been staying there.
all right, well, then you know what you have to do. You're the one
I
on,
got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house,
I
and
don't
you're-
stay there anymore. I stay with my, this one,
I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
Your Honor, I would implore the court to admonish them that contact includes calls from the jail.
It
that they're
does.
not
Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here, because he assaulted you. He's on probation for a felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, we're ready to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted you. You can go back, go. You can go with the bailiff.
What we just witnessed is a heartbreaking example of how cycles of abuse and poor decision-making can collide in the courtroom with devastating consequences. Judge Lopez made it very clear from the beginning. No contact means no contact. When a defendant is placed on probation for a violent offense, especially an aggravated assault, the court's primary focus is public safety and victim protection. In this case, Brandon Bell violated nearly every cornerstone of his probation, from multiple failed drug tests to contact with his victim, even after repeated warnings. On paper, those violations may sound procedural, but in reality, they show a clear pattern of defiance. Bell wasn't just skipping paperwork. He was ignoring the structure designed to help him avoid prison time. The court gave him every chance: probation, counseling, supervision, yet each time, he chose to test the limits. But here's where things get emotionally complex. The victim, Ms. Lopez, also continued contact. She admitted that they were still seeing each other, and she's now pregnant with his child. This complicates the judge's role, because while the system aims to protect victims, it also recognizes that emotions, dependency, and family ties often pull people back into dangerous dynamics. Judge Lopez's frustration isn't just legal, it's deeply human. You can hear it in her tone when she says, "You're the one that can go to jail." That moment highlights a truth every courtroom faces. Judges can make orders, but they can't control personal choices. Let's break down the legal side for a moment. Probation revocation means that Bell's deferred sentence, that 5-year suspended term, could now be enforced. His repeated THC positives, curfew violations, and failure to complete his BIP, Batterer Intervention Program, all weigh heavily against him. And the final straw? Continued contact with the victim, a direct breach of the court's protective order. Once the judge sees that these boundaries have been completely ignored, the next step is inevitable: revocation and jail time. Another key element here is the no bond ruling. This isn't a light decision. By revoking bond, the judge is saying that letting Bell remain free poses a risk, not just to the victim, but to the community at large. It's a move courts make when they lose confidence that the defendant will comply with any conditions outside of custody. But beyond the legal terms, this hearing shows us something raw: the pain of people trapped in cycles they can't seem to escape. You can hear Ms. Lopez trying to explain how she just wanted him to leave, how they share a house, how she didn't mean to violate orders. It's messy, emotional, and deeply real. These are the moments that remind us that justice isn't just about punishment. It's about trying to protect people from the consequences of their own choices. So, what's next for Brandon Bell? The judge has reset the case for a sentencing hearing where both sides can present testimony. But given this hearing's tone and the clear violations, it's likely that Bell's deferred probation will be revoked, sending him to prison to serve part or all of his original 5-year term. And as for Ms. Lopez, she leaves the courtroom with a powerful reminder: protection orders are not suggestions, they are lifelines. Every violation puts her and her children at risk. This case is a powerful example of how even small acts of defiance can snowball into life-changing outcomes in court. It's not just about broken rules, it's about broken trust. What do you think? Should the judge have shown more leniency because of their shared children, or was this the only responsible move? Let us know your thoughts in the comments below. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay safe, stay smart, and we'll see you in the next case.